What's up, everybody, and welcome back. Today, we got some very anticipated evidence, some angry voicemails from Karen Reed to John O'Keefe the night all this happened. Did they finally prove motive? Plus, we get the medical expert testimony. How did this happen? What is the cause and manner of death for John O'Keefe in January 28th, 29th, early morning, late night? We'll talk about all that and more when we think this case is going to go to a jury. Apparently, we have somewhat of a timeline. We'll talk about that and what our plan is. We'll answer your questions. Let's get into it. All right. So today was a wild day. I'm a little bit tired. I worked in the morning for a couple hours, then had to drive all the way to Orlando for a rules committee meeting and all the way back. And Orlando's only supposed to be 90 minutes, but it always seems to take 2.5 to 3 hours to get there. So I listened to the morning session on the way there and then the afternoon session of court on the way back. So I was listening and driving. It was very interesting to follow this testimony today. And it seems as if the Commonwealth's case is almost done. However, we are not going to close the book on it until it is actually done. And they finished basically by focusing on motive and the medical experts. And like everything else, the medical testimony focused as much on disproving the defense's theory as it did in proving the Commonwealth's theory. But we'll wait till we get there. Also, some cool stuff happened at the Rules Committee meeting. I'll try to remember to talk about it at the end, John, if you can remind. It was kind of a cool thing. I ran into a judge I tried a case in front of, and it was my last one on the Civil Rules Committee, so we can talk about that at the end. But we are going to jump right into, Guarino, however you say his name. He's back on the stand, and he talks about some of the call logs, and especially actually, before he even takes the stand, I almost forgot. The judge made her ruling. I tweeted about this already. And she is going to allow all three defense experts. No surprise. That's what we expected. But she's going to limit Dr. Russell's testimony. She can't talk about how it's inconsistent with a motor vehicle accident, which is crazy because the other doctors and medical examiners can. So I think that's totally unfair. And I feel like the defense kind of folded on that argument. Maybe they didn't want to push their luck and they knew the judge wasn't going to give them the whole expert. So they tried to, give where they could. But I think it's totally improper to allow the state's witnesses to testify about that, but not the defense when, as the judge even said, Lally basically cured all prejudice and issue with the voir dire and basically deposing this witness before she testified. So he knows what her opinions are. So where's the prejudice? Where's the harm? I don't get it. And then the judge is going to allow the other two accident reconstructionists, but she's going to even limit one of them, it seems like, with regards to the medical evidence, even though one of the medical experts seems to say an expert like that would be better at talking about the velocity and how hard of a blunt force impact it would take to cause this trauma. Regardless, she's letting all three witnesses in. We'll see how much she ends up limiting them. And that's not the worst argument we had today, because we're going to talk about the next one when it comes. So the first big reveal was that Karen Reed told Laura Sullivan, I believe, that she found John O'Keefe in the snow at 5 a.m. And I saw people online saying, see, this is proof that she went to the house first and then went to McCabe and Roberts and all them and then went out looking for him. Certainly didn't feel that way when McCabe and Albert were saying she said she wanted to go here, there, and then she said she wanted to go to Fairview, but she doesn't remember where she left him at Fairview and things like that. Very strange behavior from somebody who just did what she's accused of doing here. So I don't know what that proves. Instead, they found him closer to 6 a.m. than 5 a.m. I don't know what to make of it. If people want to say that's a smoking gun, fine. It's definitely a discrepancy in the time. Okay, I don't see it as much. I'll just say from my perspective. Then we start talking about voicemails and calls to John O'Keefe. The call shows answered from Karen Reed's logs, but missed from John O'Keefe's. I thought that was weird. They didn't really explain it. From 12:30 a.m. to 6 a.m., over 50 calls, and none show as answered on O'Keefe's phone. 8 voicemails on John O'Keefe's phone from Karen Reed. Nobody else called, which there's two ways to look at this, right? When you have a case like this where everybody is so opposed and on their side and doesn't want to hear what the other side has to say, It seems easy for people to come to their conclusion. It's harder for me because when I look at a lot of this, I could see Karen Reed calling him 50 times, leaving 8 voicemails as she thinks maybe she did hit him. Intent, there is 0%. I think beyond a reasonable doubt, the Commonwealth has proven this was not an intentional act. Throughout the entirety of the case, I think they've proven this is not an intentional act. So I'm just going to try to figure out if I think they even proved a negligent crime in this situation. And so maybe she thinks maybe I did something wrong. But if she really thought that, wouldn't she have gone and checked as opposed to just calling him 50 times? Because calling him 50 times and leaving these voicemails makes me think she thought he was out on the prowl. And we'll get to the content of the voicemails in a minute. But I really think it's strange for the Commonwealth to act like this proves that she knew she ended his life based on this contact, because I don't see it. Now, when he's supposed to show up somewhere and he doesn't, what is she supposed to think, right? She thinks he's coming home. She tries to bait him to come home and he doesn't. Then for what I thought was potentially the biggest reveal of the day that we're going to listen to first is when Karen Reed's cell phone connected to John O'Keefe's Wi-Fi at his house.
From your review of the defendant's phone, before we get to those, from your review of the defendant's phone, what, if anything, were you able to observe or ascertain that the defendant's phone did at approximately 12:36 a.m.?
So by looking at the timeline in the phone, we're able to see that Ms. Reed's phone auto-connected to John O'Keefe's Wi-Fi at his house at 12:36 a.m.
So auto-connected, and I'll just say, not a cell phone expert, but I have an iPhone and it happens to auto-connect at certain spots. That just means when you've linked to it before and you have it as auto-join where you live or maybe where you stay a lot, you show up there, it auto-joins. At my office, at my house, at my parents' house, it auto-joins. So hers auto-joined at 12:36. I'm going to let him finish his thought, and then we're going to jump to another video for a second.
We know this because it's a password protected access to the phone. So you would have to know the password to get into this Wi-Fi network.
And that would be the home at 1 Meadows Avenue, correct?
Yes, that's correct.
And Your Honor, with the court's permission, if we could publish each of the 8 voicemails to the jury.
Okay.
So before we publish the voicemails, I am going to bring another video up on the screen real quick, just in case anybody's forgotten. I had to go remind myself of this because this is what I thought. This is the prosecutor's opening statement about their timeline. Okay? We just heard, according to the data, and this is a point, the Commonwealth is not saying this is wrong or don't believe what the cell phone report puts out. There's more of that coming later, which I just think logic would tell you that's going to be hard for a jury to do when you present a document that says deleted or says a search is at this time. I think they've put up some pretty compelling evidence for some of it, but others, it's like, man, how much are you telling me? Are you showing me a picture and say, don't believe the picture shows what it says? So here's the Commonwealth's opening statement.
The vehicle based on its known locations and travel, key cycles, essentially opines, anticipate he'll opine that around 12:45 in the morning when the vehicle was in front of the residence on Fairview, that for some perceptible period of time, that vehicle traveled over 60 feet in reverse at over approximately 24.2 miles per hour. Now, you'll hear testimony.
So how is it physically possible that Karen Reed was driving her car in front of 34 Fairview, reversing 60 feet at 24 miles an hour at 12:45 in the morning? And I listened closely to the rest of Guarino's direct. I listened really closely because I was trying to figure out, are they going to fix this somehow? Are they going to explain how the timing could be off a little bit? 10 minutes here, 8 minutes there, whatever. We've heard a lot of stuff like that. Why in the world would they just produce a timeline that doesn't match up? One expert says 12:45, the key cycles, the data from the car shows right in front of the house, boom. The cell phone guy says 12:36, she's at John O'Keefe's house. This is what I mean when I say the state is not proving this case beyond a reasonable doubt. Their own timeline is inconsistent. Their evidence does not match up. So when a defense attorney has a jury instruction that says you can find reasonable doubt in conflicts in the state's own evidence, you talk about these two experts. The data, forget about the cover-up, forget about the conflicts of interest, forget about credibility of witnesses. Even if you give the state the benefit of the doubt, they did not prove this happened the way they said it happened. I just don't get it. I honestly don't get it. But we are going to listen to these voicemails now, and I want to know from you guys how damning you think they are. I am going to slow down the video a little bit so we can try to hear what she says. Some of them are hard for me to even make out what she's saying. And let's also remember, while they're not listening to it on 1.25 speed, the jury's listening to it one time at this point. So how effective is this type of evidence the first time you hear it?
Are we going to hear which time each one is?
Yes. Messages, just for point of reference. The earliest of the voicemails is the last in the list, and the most recent is at the top of the list. Is that correct?
Yes.
Now, as far as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Ms. Gilman, if you could have these.
John, I effing hate you. Okay, that's 12:36. Got it.
Second message. Sorry, Ms. Gilman, if you could pause right there, please. I apologize. I just wanted the siren to go by.
Oh, that's fine.
And before Ms. Gilman presses play again, Trooper Garino, what time is the second message?
12:42.
Ms. Gilman, if you could.
I don't really know what that is outside of someone walking. Maybe you guys do. I don't know how the jury could gather anything from that.
Now, Trooper Garino, with reference to the third message, what time is that received?
12:59.
Yeah, Yobi, they're going to get to that later. So all these witnesses testified that after 12:36, they saw her there. I mean, that timeline doesn't work out in a million different ways. We know they left the waterfall like 12:11, 12:13, something like that. Some other people like the Alberts left at 12:14. It took 10-ish minutes or whatever to get to the Alberts house, 12:25. If she's already at John O'Keefe's house at 12:36, how is she not leaving at the same time as some of them are coming? It all doesn't make sense. It all doesn't make sense.
And again, when I say received by Mr. O'Keefe's phone, is that correct?
That's the timestamp of the voicemail in his phone, yes.
And Ms. Gilman, if you could, with reference to that third message.
John, I'm down with a fucking kid. Nobody knows what the fuck you want, fucking pervert.
Now, the
So what I gathered from that one is, I'm with your kids, you're a pervert, with some expletives. Something like that.
fourth message, Trooper Garino, what time was that received by Mr. O'Keefe's phone?
1:02 a.m.
Ms. Gilman, if you could, when you're ready.
That was it.
So can we just turn the air conditioner off?
O'Keefe's phone.
Hold on.
Yeah, it's 1 in the morning. I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert.
I'm with your niece and nephew, you effing pervert, you're an effing pervert.
And the sixth message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
Gilman, if you could.
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. She's sleeping next to me. You're a fucking loser. Fuck yourself.
You're effing another girl, you're using me, you know, the babysitter with benefits stuff kind of coming back around. And I mean, yeah, she's pissed. She's very clearly pissed, screaming at him, yelling at him, all after she knowingly hit him and left him in the snow. I'm not sure what purpose that would serve.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
Gentlemen, if you could. The last and eighth message, sir, what time was that received by Mr. O'Keefe's phone?
6:08 a.m.
Gentlemen, if you could. Gentlemen, if you could pause there for 1 second, I'm sorry. With respect to this message,
Yes, I did want to say this. If this language is motive to kill, what is the way Proctor speaks about Karen Reed? Someone he doesn't even know, doesn't have a relationship with, hasn't put a lot of time and energy into, and to feel like he's not getting it back.
received on Mr. O'Keefe's phone at 6:08 a.m. From your knowledge of the investigation, where was the defendant, who, if anyone, was with or around her at the time of this message at 6:08 a.m.?
Jen McCabe, Kerry Roberts. During the message, you can hear someone on the phone with 911.
Thank you, sir. Ms. Gilman, if you could.
People are saying these messages are a reason they upgraded it to second degree. Like, that's wild to me. That is wild to me. All right, instead of listening to the whole thing, it's kind of like that. You can't really perfectly hear what they're saying. And those are the messages. So you guys just go ahead and tell me. You can evaluate those as well as I can as potential jurors and lay people. And, you tell me how damning you think they are. Okay. And we're going to keep going through the evidence. So then we get to the fact that she called her parents a few times between 1 and 5 a.m. And then, Yobi, why does it seem like cell phone data is irrefutable evidence if it points to the guilt of a defendant, but refutable if it hurts? Not even refutable. Don't even think about it. I know some people can get confused, but that's not what it's really saying. That's what they've said multiple times, and I don't love it, okay? I don't love it because just think for a second, if you're a criminal defendant with no money or a public defender who can't or won't hire an expert for you, and the state produces Celebrite records or your key cycle data, and it's wrong and it says deleted, it doesn't actually mean deleted, and the Commonwealth may know that based on these witnesses, but it's like, makes him look guilty if he deleted the fact that he map quested the route to the girlfriend's house where the crime occurred. Looks like he deleted it. Deleting it's worse than just leaving it up there, so let's say he deleted it. That's what the data shows. How many trials do you think that happens in? Why do we use it if it's this unreliable? Speaking of that, and speaking the reliability or not reliability, unreliability of evidence, let's listen to how he explains the steps that were taken from John O'Keefe's reporting of his phone. I think it wasn't his watch. So it was his phone recording the steps and how many feet he went and things like that.
Okay. And sir, if you could just list for the jury what you found.
Yes. So at 12:11 and 9 seconds in the morning to 12:21 and 5 seconds on the 29th, it shows that he's taking 170 steps going 99.6 meters or 326 feet. At 12:21 and 10 seconds to 12:24 and 22 seconds, it shows 80 steps and 87.74 meters or 287 feet. At 12:21, 14 seconds to 12:24 and 37 seconds, it stated ascending, descending 3 floors. And then at 12.
So he just kind of glosses over that, but we're going to stop for a second. 12:11 to 21, 177 steps, 326 feet, kind of lines up with them leaving the waterfall. 1221 to 1224, 80 steps, 287 feet, ascending / descending 3 floors. Okay. So if that's the timeline, if they left at 12:11, 12:12, is it possible they're at the Albert's house by 12:23, 12:24? Seems possible. I'm not going to say that's a guarantee. And we'll get to what the state says happens there. But at least that kind of fits with the defense's timeline. And guess what? If she leaves at 12:24, she very easily could have made it back to John O'Keefe's house by 12:36 to log into his Wi-Fi. That all kind of lines up, and she thinks he went into the Albert's house and walked up or downstairs. So from what the defense is selling, this is kind of in line with that. So the state's got to explain that, right? And we'll see how they explain it. I Am Groot said Karen Reed's dad even said she said she hit something. Google the Ted Daniels interview with her parents. So I don't mean any disrespect when I say this, but I'm not going to Google anything. I'm not going to watch any interviews. I'm not going to look at any pretrial motions or hearings. I don't want to see anything that the jury's not going to see or hear. So the Commonwealth can call her dad and ask him, what did Karen Reed tell you? That's not hearsay. It's an exception because she's a party opponent. If the evidence comes in that way, great. And I'll listen to it. I'll consider it. But I'm trying to just keep my purview and scope into just what the jury's hearing. And I'm not going to say at the end of this trial, Karen Reed did it or didn't do it. I'm going to talk about whether or not I think the Commonwealth proved their case beyond reasonable doubt. All right, let's continue listening to the step data.
31:56 to 12:32, 16 in the morning, 36 steps, 25.46 meters or 85 feet.
Now, sir, with respect to what's listed as steps, does that, based on your training experience and familiarity with this sort of health data, what, if anything, does that tell you as to whether or not the person with the phone is physically taking steps?
That's not the case.
What is the case?
So I don't mean to laugh. Obviously, it's not a funny thing, but it's just like ironic that if it doesn't work for you, the step data doesn't actually mean step. Now, these voicemails and these calls, all these missed calls Karen Reed had to John O'Keefe, that's exactly what they meant because she's a crazy ex-girlfriend. But the deleted stuff, the Google search time, the step call data, that's not really what it looks like. Okay? Now, we know this from even with the Apple Watch. He's like, well, with the Apple Watch, it's a lot more legit or reliable, but we know people can just do this. Sure, same thing with your phone. But is it counting driving as steps? That seems kind of weird to me. Like the phones don't differentiate between driving and walking and taking steps up and down stairs. I find that weird. Maybe it is the case. Again, not an expert, but I don't know. It just seems illogical to me.
Like I said, the phone has internal measures. The phone has internal measures in it. Like I said, it's basically a pedometer. So the movement of the phone, the distance traveled, it's going to register as steps. You don't have to physically be walking and moving the phone for it to register movements. Just waving it around and then could potentially cause it to think you're walking and moving.
You mentioned that from your review of Mr. O'Keefe's phone, you indicated there was a Waze search for 34 Fairview Road. Is that correct?
Yes, that's correct.
And if you could just explain to the jury sort of what is Waze and what kind of information are you looking at there?
Waze is a GPS program. So you put your address you're looking to go to. It's going to tell you the fastest route, where the police are, etc.
And when that Waze search was conducted, is there a precise time pursuant to your review of Mr. O'Keefe's phone associated with that Waze search?
Yes, it was 12:20 in the morning.
And so from all of those steps and everything that you, if Mr. O'Keefe is searching for 34 Fairview Road, inferably he's not at 34 Fairview Road. Is that correct?
That is correct.
Now, with respect to...
Right, but it's from 12:11 to 12:24. Basically, we have all this data. So what time, and what I don't like, okay, what I don't like, and again, this might be why I'm not on a jury, because I would know this, that maybe a layperson wouldn't know, but in a normal case, if you're a prosecutor, you've asked all these witnesses how long it takes to get everywhere. So is it possible for Karen Reed to still be Wazing and Googling and looking up inside of her car with John O'Keefe how to get to the Albert's house at 12:24 and drive to his house, 3-point turn, 24 miles an hour, 60 feet rear end, go in reverse, and still get to John O'Keefe's house by 12:36? Is that possible? And if it is, show me. Show it to me like I'm 5. Give me a chart, put it up on a graph, whatever it is. Explain to me how that can work, because in my head, that doesn't work. That doesn't line up.
The location. Can you describe to the jury, are you familiar with the term based on your training experience known as native locations?
Yes.
And can you explain to the jury what that is?
So native locations on an iPhone, the way it pulls GPS data, it uses satellite, Wi-Fi signal, Bluetooth, location services on apps. It takes all that data and uses it to get you the best location of where you are, unlike where you'd have like a handheld car-mounted Garmin GPS that's just using strictly satellite.
Now, from your review of that data, when that wave search is conducted at approximately 12:20 a.m., where is Mr. O'Keefe physically located at that time?
The vehicle, or whatever they're in, is by 138 Dedham Street. They had already passed Cedar Crest Road.
And from review of that native location data, what time does the phone arrive in the area of 34 Fairview Road?
12:24 a.m.
Now,
So then that right there, okay, 12:24 a.m. The steps, as confirmed, I think in cross or in direct, I don't even remember. The steps don't mean they started at 12:21 and ended at 12:24. Okay, they don't mean anything they say on the paper apparently. So all 80 steps, 287 feet. Which, how the heck do you go 287 feet and 80 steps? I mean, I think that's even like shows how unreliable this is. But if the defense's theory, and if they want to paint a picture like I'm a 5-year-old, they could say they got there at 12:24. He immediately goes inside the house and right down the flight of steps, all within that 12:24 minute. It doesn't take 5 minutes to walk inside a house. This stuff fits better in the defense's theory than it does in the Commonwealth's theory. I don't think it's perfect. It's far from perfect in the defense's theory. A lot of things don't line up or make sense to me in the defense's theory. But this timeline and this data certainly does not make sense with the state's theory.
the next entry is
Actually, we're going to jump to the next part here. He talks about how the signal's not great at 34 Fairview. He knows because he drives by there all the time. And he used Google Maps basically to build out where they went that night. And that we're going to watch some of that.
Now, with respect to the data that you were able to recover, if you could describe to the jury sort of the path of travel, starting with the waterfall as far as where Mr. O'Keefe's phone was, where it traveled in it, and where you noted it at various time points along that sequence.
Okay. So as I said, at 12:12, it's at the waterfall bar. Then there's a 7-minute break in location data. When the phone comes back up with location data at 12:19, as I said, he's by Dedham Street and Cedar Crest Road. At 138 Dedham Street, right around there, 12:20 a.m., 34 Fairview is put into Waze. He then proceeds down Dedham Street, takes a left onto Oakdale Road. It goes to the end of Oakdale, takes a left onto Maplecroft. As he's going by Maplecroft and Pinecone Road, right around 12:22 and 14 seconds, was a data point listed that he's ascending, descending the stairs. So he's over a half mile away from 34 Fairview at this point. They go down Maplecroft, take a right onto Cedar Crest, all the way down Cedar Crest. They do not turn onto Fairview Road. It goes by Fairview, does a 3-point turn or turns around somehow, and then goes back to Fairview and takes a right, where it finally stops between 34 and 32
I love how much they're saying the 3-point turn thing.
Fairview.
So at the time that that health data is being recorded, and you cross-reference the GPS data with the health data for Mr. O'Keefe's phone, correct?
Yes, that's correct.
And so at the time that the phone has that recording of the health data descending, and is it ascending or descending, or how does that read in the health data?
I have my report, and that's what's copied from the thing. It's ascending/descending stairs.
And at that point in time, cross-referencing.
It is absolutely, I'm not saying what he's about to say is not true. It could very well be true. I'm not saying he like took an oath and lied on the stand and whatever, but it is just mind-boggling to me that in today's day and age, in 2024, where they know everything, Big Brother is watching everything. They're tracking our movements, they're tracking what we like, what we don't like, all in the name of selling us what we want, but really just to be able to control and have all this information, whatever. In today's day and age, we can have data from a report that says you're ascending or descending stairs, but instead it can mean this.
That health data with the GPS location, where physically is Mr. O'Keefe's phone at that particular time frame?
Maplecroft by Pinecone Road, right at that intersection.
And has Mr. O'Keefe's phone arrived or been in the area as far as the GPS, specifically of 34 Fairview Road?
At that time?
Yes.
No, not at all.
And so from the GPS locations that you observed of the defendant's phone, initially the phone passes by Fairview Road and then reverses direction to come back, correct?
Yes, that's correct.
And then as far as between 12:25 a.m. and 6:15 a.m., there's no movement of that phone, correct?
The phone system.
What, if any, movement did you observe following 12:25 a.m. until the period of 6:15 a.m.?
None until it was found at 6:15.
Now, you mentioned that you took a tool and you did some measurements as well. Is that correct?
Even that, right? Even that. So at 12:24, he immediately gets out she immediately hits him and immediately leaves. Is that the state's theory? Because they didn't say that she hit him at 12:24 or 12:25 or 12:30, but 12:45. So even their own evidence doesn't go in their timeline. It's very, very interesting.
Yes.
And were you able to ascertain then some GPS locations for where Mr. O'Keefe's body was found?
Yes.
And what, if any, measurements, excuse me, the accuracy of those GPS measurements and latitude and longitude, what was the accuracy of that?
Let me read the exact notation. All right. So from 12:25 and 30 seconds to about 12:35 and 36 seconds, the GPS accuracy is tight on him for the first few seconds and then blows out and encompasses pretty much the.
So here's another thing. We're just going to hear about a minute of this. He had a couple minutes of it, but it's like sometimes the accuracy is really good. Sometimes it's really bad. And it's like broad and wide. And, you know, so we're not as pinpointed on where somebody or something is.
Neighborhood 34 Fairview, 32, 31, and I'll read the exact. It's at 12:25, 30 seconds. It has a 33 meter degree of accuracy, which is about 100 feet. That area encompasses 32, 34, and 31 Fairview. 12:25, 31. It's 200 foot measure for accuracy that hits 31, 32, 34 Fairview. Basically, almost all the houses around. At 32 seconds, shrinks back down to 95 foot level of accuracy, hitting 32, 34 Fairview and the front yard of 31. At 33 seconds, it's 88 feet. Again, shrinking back in as the signal gets better. Covering 32, 34 Fairview, 72 feet at 34 seconds, 59 feet at 35 seconds, and then 52 feet at 36 seconds. So, as I said, signal weakens, it blows out, and then as signal gets stronger, it shrinks back in. The GPS coordinates themselves are all still right where Mr. O'Keefe's body was found.
And so as far as, if I can take it back just for a second, the initial GPS coordinates that you marked as far as where Mr. O'Keefe's body was found, how accurate was that measurement as far as to itself where it was?
From what we had and then where we marked from, we believe we're in about 3 feet because standing there, even with the app, it's not perfect. I'm not getting a direct saying that I'm right on it. So we believe we're within about 3 feet of exactly where he was found.
We believe.
And from that air distance of within 3 feet of where Mr. O'Keefe's body was found, how far was that, or how far did you measure that to be from the front door of 34 Fairview Road?
In a direct straight line to the front door, 72 feet. Not counting the stairs.
Now, from your review of that data that you were talking about from that 12:30.
All right. So I want to show you some of the, maps that he showed them to show what this looked like. These carrots here are John O'Keefe's phone, and it's all right kind of where they need it to be. All that makes sense. All that looks good for the Commonwealth. Then they show this one real quick spot here. If you can see up right by the house, there's a little black line, and he's like, disregard that. That's not legitimate. That's not where he was. And this is more accurate than Cellbrite. So we can just trust this. Okay. Then more on what that ascending or descending stairs could really mean based on the route they took and the time it said he was going up or downstairs.
And then it goes up. And then as you go down Cedar Crest, the hill is about 50. And this is referenced it with the points. This is Pine Cone Road, and then Maplecroft intersects here. And this is the ascending, descending stairs points in his phone. Doing a Google Earth elevation check. There's about a 20-degree dip, and then it goes up. And then as you go down Cedar Crest, the hill is about a 50-foot elevation change again. So it's pretty significant.
And so I'm sorry, sir, as far as the elevation change that you're talking about, how is that measured, and how and where is that in reference to what's picked up here?
So again, like I said, in this area here, there's about a 20-foot drop. And then as you go down Cedar Crest, that hill is about 50 feet. This spot here is the ascending, descending stairs. So as I said before, he doesn't have an iWatch on, so it's not collecting that great health data. It's still acting as a speedometer. So again, whatever movement he's doing is triggering something in the phone as he's ascending and descending these hills. Essentially, it could be tricking the phone.
So the ascending and descending stairs is actually ascending and descending hills. I'm not going to say that's impossible. Okay, I'm not. Why did the reports not just say ascending and descending? Why do they say steps and stairs and things like that? I just don't get it. I don't get what the point of it is. If that's what it's doing, it's so confusing, and it's bad for the criminal justice system to use this stuff regardless, because it can either create reasonable doubt in cases where there shouldn't be reasonable doubt, or the prosecutors can just let it kind of read how it reads, and it puts too much control and power in their hands. Mama Pink said her phone logs steps when she's sitting a lot. Yeah, I'm not saying that can't happen. I'm not at all. I'm just saying, like, how many times are they going to tell us this piece of evidence we're showing you that shows this is not really what it looks like it's showing? I wouldn't feel great about that. I wouldn't feel great about that as an attorney on a civil case or a criminal case if I was prosecuting it.
Going into thinking it's stairs.
Let's come if I can have the next slide. Trooper Marino, what are we looking at in this one?
This timestamp is 12:19, 32 seconds. That's when the phone initially starts creating the GPS points before Waze is activated with 34 views searched. So this looks to be the time Waze is actually opened up.
And so from the purple dots that are picking on the screen, as far as where is Mr. O'Keefe's phone at
I
12:19?
also feel like you'd be able to know exactly where Waze opened up, because doesn't it start the route right from where you are?
a.m. in reference to 34 Fairview Road.
12:19 is right here. 34 Fairview's down all the way here. Number, you can't really see, but it's right in the bottom corner.
And the next slide. Let's go.
So
This is the same map.
So Brandon Reed said, as a software engineer who has worked on a step counting app, step data is completely unreliable. I'm getting sick of seeing it loud in trials. It was very, very big in the Alex Murdoch trial. He was real busy. What was he doing with all those steps? He was working up a real sweat, remember? That's how the prosecutors used the step data in that case. And everybody was okay with it. I mean, it sounded plausible to me. It said he took steps. The jurors are not software engineers. Maybe one or two of them might be, just with a cross-section of society. But that's why we as the lawyers need to make sure what we are presenting is reliable and is legit, as the kids say. Okay, now we are going to get to one of the most miserable parts of the day for me. I don't get shocked easily, but I was shocked when I heard what the Commonwealth wanted to try to bring in this case.
February 29th, 2020.
Put it back in session to be defeated.
All right, so Ms. Giannetti, did that give you enough time?
I have enough time.
Okay. All right, so Ms. McLaughlin, why don't I hear you just briefly? If you could frame this, or Mr. Lally, whoever wants to.
Yes, Your Honor, the Commonwealth is moving to introduce a Google search the defendant conducted at 1:27 p.m. on January 29th, 2020.
1:27 p.m., January 29th. Not 1:27 a.m., which is what I thought it was the first time I heard it. And I was like, well, it's interesting. I still think totally inadmissible, but that's interesting just as far as like what really happened. But no, this was 1:27 p.m. on the 29th, okay? Everybody seems to agree John O'Keefe died somewhere between 12:25 and 1 o'clock in the morning. Actually, I don't know. Maybe the defense says it was later. I don't know. But after 12:30 a.m., but early in the a.m., right? So a 1:27 p.m. Google search is what they want to enter.
The Commonwealth would argue that the probative value of this Google search outweighs any prejudice to the defendant. The search in question is at 1:27 p.m. before the defendant had spoken to law enforcement. She conducted a search for DUI attorneys. The Commonwealth thinks that this is appropriate for the jury to hear as it.
She searched DUI attorneys at 1:27 p.m. I have so many thoughts on this. It's not even funny. I don't want to take the whole video talking about this, but so first off, for evidence to come in, it has to be reliable. It has to be relevant, which means tends to prove or disprove a material fact in this trial. So let's listen to why they think it's relevant and should come in.
Rebuts the voting defense that the defendant has laid out. Commonwealth thinks that this is appropriate for the jury to hear as it rebuts the voting defense that the defendant has laid out. Not that she did not intend to commit John O'Keefe. The defense has been that the defendant is essentially what's been represented in open court was framed that she had no intent or opportunity to commit these crimes. Further, that she was not intoxicated at the time. So the Commonwealth feels that the probative value significantly outweighs.
So searching for a DUI attorney proves you have intent and opportunity to commit an intentional crime. That's just flat out wrong. It doesn't prove that in any world. It only proves that she felt like she had an attorney, and prosecutors want to say only guilty people hire attorneys, and they hope that there's somebody on the jury that agrees with them, that only guilty people hire attorneys. This steps on basically every fundamental right, but especially your right to counsel, your right to remain silent, your right to a fair trial. It steps on literally every right, and does exactly what prosecutors are forbidden to do, which is comment on the defendant's right to have an attorney. That's literally all this is. She knew she did it. That's why she hired a DUI attorney, or was looking for a DUI attorney. Now, they're going to say it's before anybody talked to her. The defense argues Proctor called her from his personal cell phone at 1:19. But it's despicable for the Commonwealth to do this. They're lawyers. I heard, of course, some people on Twitter telling me, oh, see, you just don't want everybody to know she knew she was guilty at 1:27. It's like, sir or ma'am, I physically cannot have this discussion with you because you just don't understand how America works. Innocent people hire lawyers all the time, and they have to, a lot of times, to fight for their innocence. Guilty people get railroaded. Innocent people get railroaded by not having an attorney all the time. And that's not how our system is set up. But even if this did come in, which it never would, and it's not, even though Bev kind of left the door open, isn't it strange how she searched for a DUI attorney, not a murder attorney, not a hit and run attorney, not a DUI manslaughter attorney? That's strange to me. Just if in my mind, I do want to try to figure out, did she do it? Did she not do it? Which I'm not really trying to do. I'm trying to see, did the state prove the case beyond a reasonable doubt? But her searching for DUI attorney really makes me think she doesn't think she hit him. It's a very, very weird circumstance to me that a lawyer would argue to get this in at trial. It's really sad. And this is where I feel confident these prosecutors are more interested in winning this trial than fighting for truth and justice. And guess what? They may be right. She may be guilty. They may win. This is still wrong. This is still something that their supervisors or the legislature in this state should have something to say about. You cannot have your prosecutors wanting to do stuff like this because God forbid they let it in. God forbid a defense attorney didn't fight it. God forbid a judge just said yes. Oh, okay, then the defendant can appeal it as if that's easy. It's an abomination. Like, this is 101 type stuff. You know you cannot do this. The media may be able to do it. The people on the news may be able to do it. People on Twitter, on YouTube even, they may be able to say anybody who hires a lawyer is guilty, fine, whatever. For prosecutors to want to put it in front of a jury is crazy to me. It's crazy.
Ways of prejudicial value. It goes to her state of mind at the time that the search was conducted. Further, it also rebuts that there was any impropriety in the police investigation, or that, as the defendant has put it, that the police did not search any or investigate any other potential culprits. It also would go to the defendant's consciousness of guilt at that time. This statement is before she voluntarily gave an interview with law enforcement. It goes to her
consciousness of guilt. Again, they want to say, because you want a lawyer, you are guilty. That's what the people that prosecute crimes in the Commonwealth here want to tell a jury. And you know what else this does? This has a stifling effect on people in the future. Gosh, I know that they're going to think I'm guilty if I hire a lawyer. Maybe I can talk my way out of it. And then they're going to use whatever you say against you. This is not how it's supposed to be to the nth degree. I don't care what side of this case you're on. You should not want this.
state of mind prior to that interview. And so for all those reasons, the Commonwealth would suggest that that Google search is appropriate. And it's not a typical case where it's an invocation of counsel, where law enforcement had not engaged her, and it goes to her state of mind at that time prior to any police involvement, and further to rebut that there was any improprieties in the police investigation, or that they should have investigated anyone else.
All right. And I appreciate.
Yes, I don't know if this lady is Lally's supervisor or if Lally is her supervisor, but if he is her supervisor and he had her argue this motion, I've got some other thoughts and feelings on Lally to let her sit on this grenade in his trial.
Mr. Lally, you bringing this to our attention to give us time to look at it. Ms. McLaughlin, I appreciate that you provided a very strong limiting instruction.
I don't appreciate it at all. And that's a joke that the judge is appreciating and complimenting the way they're bringing up this despicable motion. And I have not been overly harsh to any of the lawyers in this case. And I don't like to do that for no reason. I don't like to call people stupid or idiots or anything like that. I don't like to do that. I really don't. I try hard not to, actually. Shirt says grace on it, right? That's what I'm always trying to give, grace. It's what I need a lot. But this is, you cannot do this stuff. Somebody needs to remind them in a very serious way. Not me. I mean, somebody that matters needs to remind them in a very serious way.
Proposal. I'll hear you, Ms. Giannetti.
Thank you. Your Honor, you had asked us I use proof of the phone call from Michael Clark for 2 months.
Oh, I didn't say proof. No, I asked if that was coming into evidence.
Okay, well, I'd like this mark for identification for the purpose of this argument, if I could.
Sure.
Show counsel. It's been redacted.
Okay. So let's have it marked for ID before I hear you any further. So Madam Court Reporter needs to mark it. All right, and if I may have that. Thank you very much. Just give me a minute, Ms. Giannetti. That a call occurred.
To my client at 1:19 was made from Michael Clark's personal cell phone number. You can see the last 4 digits there. To my client at 1:19 p.m. on January 29th.
Okay.
Approximately 8 minutes before she calls to investigate potential DUI.
Okay, so focus on the law for me and tell me why I should exclude this.
Of course, yes. With regard to the cases that Commonwealth has cited, I think the court has seen one of them is an unpublished opinion, the other is a homicide case. It couldn't be more distinguishable from this case. With regard to the unpublished,
The sites that the cases they cited, listen to what they argue as evidence that this should come in this case.
opinion, that appears to have been a gun charge where the defendant in that case did a search for a 9mm handgun on his cell phone. He did not ask for Google or search in Google for a handgun attorney. He made.
So they said this guy searched for a handgun. It's the same thing as her searching for an attorney. It's like, except that that's a very specific protection in our country that we take very seriously. And instead, if you search for guns, sure, that can come up. Just like if you search how long to die in the cold. But getting an attorney is not, it's emphatically and legally not consciousness of guilt. That's a fact. That is not something we argue about in the court of law. In the world, and lay people and media, on YouTube, Twitter, sure. You can argue about it if you want. I know where I stand on that. But legally, lawyers know that's not consciousness of guilt.
A specific inculpatory search that the court ruled was relevant and was not outweighed by the danger of unfair prejudice in this case. But we have a person being contacted by the police and then doing what a citizen has every right to do, which is to look for an attorney for representation. There's zero probative value to that, other than she's presumed to be innocent and she's seeking an attorney to defend that presumption of innocence. That's it. There's zero probative value. But there's an extreme and unfair prejudice in this case.
By the way, also, she's got lawyers. The jury, I think, has figured out she hired lawyers. So it's not like that's a secret. So when she searched for one, also doesn't prove anything because the jury already knows she, in fact, has lawyers.
Your Honor, the limited instruction that the Commonwealth has provided asks this court to instruct the jury whether her action in doing an internet search for an attorney indicates feelings of guilt by a defendant. I can't even believe that argument.
So let's just focus on the law.
She stops him. Bev stops him. It's like, no, this is what every lawyer in the country is thinking, Judge. She stops him. She denies it before he can make the very, over the top, I'm shocked and offended argument, which at times in this trial, maybe the lawyers have played some things up for the camera, whatever. This isn't one of those times. This is truly despicable.
I'm trying to, Your Honor. I'm fired out.
So what I'm going to do then is I'm going to stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial effect.
Okay.
All right. So I'm not going to allow it in, Mr. Lally, in your case in chief. Now, if you feel that through this witness or through any other witness, Mr. Lally, that it then is admissible, I just ask that you come to sidebar beforehand.
The fact that she even thinks that could become admissible, I would love to figure out how that would become admissible. If she takes the stand and said, I never Google searched an attorney at 127, then I think it could be admissible for impeachment. Outside of that, I can't figure out how that would become admissible. So that really chapped my you-know-what. Okay, so I guess it's not over. It could still come in later. Then we get cross-examination of this witness. Before we get to cross, let me answer some questions. They're starting to pile up here a little bit. Amy, I feel like the prosecution doesn't even believe in their own case. Maybe they are just going through the motions because he's a cop. Doesn't feel like that, especially when they press on arguments like this. I said Ashley, I think. Amy. Rebecca, they let the cops testify on the medical stuff. Why not the medical person? So they're not necessarily medical doctors, but PhDs, biomechanical engineers, and they're not necessarily testifying to the medicine, but instead the force applied to cause injuries. I don't get why she's not letting them testify to that. And then if you're talking about the medical expert testifying with injuries, I'm sorry, the medical doctor, maybe that's what you're talking about, the ER doctor, which probably you would know a lot about, should absolutely be able to testify to the fact that it's consistent or not consistent with a car accident. It's crazy that she can't. She's definitely treated more car accidents than dog bites. I guarantee that. Veronica, Peter, what if John was attacked by Chloe, the dog, fell backwards, cracked his skull, and everyone panicked? Would the Alberts even be responsible? Potentially not. Potentially not. But once you do a cover up, then you're in trouble. Not saying that's what happened, but I mean, if it was an accident, it was an accident. And if they could do all this that the defense is accusing them of doing, I'm pretty sure they could have taken care of an accident, a legitimate accident. Does Lally know he works for the prosecution? Pretty sure it's where his paychecks come from, but you might not always know it. I am Groot. How can they get the dog bite info in from the voir dire that goes to third-party defense? They haven't proved any of it for it to be in the closing. I mean, the dog bite stuff is coming in because it's relevant. It's a fact. It tends to prove or disprove a material fact, and that's what comes in at trial. So I'm not sure. I think people are misunderstanding this whole like third-party culprit. There's got to be evidence that says this guy did it, and it's I have a Ring doorbell camera that it was Colin Albert. That's not what you need to make a third-party culprit argument. This type of evidence is how you can build toward a third-party culprit. Why is he calling him if he's still in the car? Yeah, I don't know. Right? If she's still with him, why would she be calling him, screaming at him and texting him? Susie, O-Town, it's not a bad drive. Oh, we must drive at different times. Hubby and I make the drive to Clearwater almost weekly in the summer to take the kiddos to the beach. Okay, so I just know now you have proven to me you're more patient than I am to drive from Orlando to the beach. I barely drive from my house to the beach. The traffic's so bad. Jen, Pita, honest thoughts on where the jury stands after today's testimony? Honestly, it's hard for me to gauge that. From my perspective, I think if they understand reasonable doubt, they still have to be in that camp at this point. I don't know that they're in the camp of proven cover up, but Matthew, what type of AC unit is in the room if they need to turn it off to be able to hear? It's a great unanswerable question for me, Matthew. Veronica, Peter, what happens if the jury finds Karen Reed not guilty? Is that the end of the case, or can John's death still be investigated? They can still investigate it. My guess is they won't. It's very difficult to try a different person on the same set of facts or circumstances, or the new defendant could point to this case and Karen Reed as a third-party culprit for reasonable doubt. Susan, Peter, what's to say J.O. didn't simply leave the house unnoticed, fell, got injured, and then passed out drunk in the snow, sort of like those guys that froze to death at the Super Bowl party? What's not to say that? I'll tell you what's not to say that. The Commonwealth. They have said that didn't happen, and we can prove beyond a reasonable doubt that that didn't happen. That's what's to say. I think that's plausible. I think that is possible because we can't really prove what happened. So there's a lot of plausible ideas of what could have happened. John, I feel like Karen Reed ran him over, but the prosecution can't prove it. This is a dog eat dog world out there. Karen Reed has dirt on her hands. Don't hate the player, hate Karen Reed. I mean, if they can't prove it, it's on the Commonwealth. Joe, is there enough for the defense to win directed verdicts? No. For one or all charges, if Karen Reed is acquitted on all, is there enough to sue for malicious prosecution? There's probably enough to sue for something civilly, but I don't think there's enough for a directed verdict with this judge. Pterodactyl. Peter, could this be an issue with Apple if the info doesn't have the steps? Could just wave phone around? Hills could record as stairs, etc. is incorrect. I mean, if I don't really know. I don't know the interworkings of who produces the report, how the data goes in and out. So it's hard for me to answer this question because I don't know who's responsible for what. B&B. If someone on this jury has an iPhone and uses the health app, they will know the steps will not record while in the car. So in that case, can they choose to ignore this witness? So we've had people in this chat say it does or it doesn't. Yes, they can choose to think that this witness is not credible. They can say, I know what he's saying is false from my own personal experience, and I'm discrediting his testimony. J. Baywatch, if KR is found not guilty, what can we locals do to convey that we have lost faith in the impartiality of the process and its stewards? It's scary to think this could happen to any of us or our loved ones. So local elections, I don't know if you elect your prosecutor or your judges. That's always really important. Talk to your local legislators, your state legislators about the problem here, and that the rules are not followed appropriately and that cops aren't held to a better standard and they're not disciplined when they obviously should be. That's really all you can do with your voice and vote. Deb, hey, Peter, do you remember when Colin's sister testified that Colin was in the house at the same time as John? Did anyone ever question this? Did I miss it? I think it was kind of a slip of the tongue is what everybody left it at, but I don't know if the defense will dig into it more. Michelle, those voicemails weren't contrived. Guilty people send voicemails after the crime to make themselves look worried. She is pissed. And to me, this is the most compelling evidence of her innocence so far. BC, the jury drove there. Can they look at their Apple Health data? I don't know. I don't know how to look at my Apple Health data. I don't know if they do. Allison, I just want to say I'm hooked. Years of following true crime and lawyer view channels, and this by far is heads and shoulders above all others. Love Peter and Papa too. Never stop broadcasting. My first super. Hope it's not nerdy AF. Allison, thank you so much. Thank you for being here. All the comments and questions make this what it is. I've always said that. I still firmly believe that. Let's get to cross-examination of this witness. So he talks about how you disagree with my defense expert. He goes through the experience and education of this person to show and compare to his expert later. I'm sure no degrees, never taught courses, a patrolman. He talks about how you should write reports as soon as you can with all the important evidence. And the cop with a straight face argues, not always as soon as you can. You don't always keep all the important stuff in there. Sometimes it's too long. It's like, that's the argument you want to make? Okay. He received the phone from Proctor, but doesn't necessarily know if Proctor got it from the scene. He calls it an unintended death in his own report after talking to Proctor. That's interesting to me. April 2023 is the first time he had data location stuff in the report. Proctor had access to the phone, but he said there's no way he could have changed it. The cops didn't put it in airplane mode as soon as they should have. And then he gets into Karen Reed being not at 34 Fairview at 12:36.
Connected to the Wi-Fi at One Meadows Ave at approximately 12:36 in the morning.
Yes, sir.
So you can testify based on that by 12:36 in the morning, Karen Reed was not at 34 Fairview, correct?
That's correct.
And that was the first of those voicemails that you testified to, correct? That was the I hate you voicemail?
Yes, that's 12:37, correct.
Okay. And that voicemail and every other voicemail that the jury heard was left after Karen had left 34 Fairview, correct?
Yes, sir.
And except for the one at, after 6 in the morning, the 4-minute one when she went back, we heard that one. But all the other ones were apparently left when she was at One Meadows, correct?
I can't speak to where she was, but
she wasn't at 34 Fairview.
yes, that's correct. She wasn't at 34.
And
You could speak to where her phone was, though, I think, right? Like, I feel like he could. And Mary Claire, I would assume the defense is going to bring that up again in closing. Now, I do start to think, as a lawyer who's done a lot of closing arguments, which I might as well just tell my story now. So this judge that I tried a case in front of about a year and a half ago, who's from my county, is also on the Civil Rules Committee. And she came up to me at the committee. I was like, oh, hey, Judge, how you doing? We talked about it a little bit. She talked about the case. It's up on appeal. We just won the appeal. Now there's a bad faith claim going on. And she's like, I told your partner, because she knows Pete Sardis. She's kind of his age. And she's like, I told your partner that your closing argument was the best closing argument I've seen in over 10 years on the bench. And she said, it's the first time in a case where I was like, everything I was thinking to myself, because she takes a ton of notes during trial. She's like, I would have said that. Oh, he said it. I would say this. Oh, he said it. And I was like, Judge, I can't tell you how awesome that is and how huge of a compliment that is. And if you have any notes on any case I ever try in front of you, I'd love to hear them. Because when judges, they don't have to say anything, right? I mean, they know it's our job. They know we get paid to do our job. For them to actually say stuff means so much to the lawyers, just like talking to jurors. Talking to judges is awesome too, because they're unbiased. They see way more than we do. They see tons of lawyers, the best, the worst. And the ones in the middle, they see more trials than everybody because they're the ones trying all the cases or having the cases tried in front of them. So I thought that was awesome. So anyways, as somebody who tries to, really tighten up closing arguments, there's so much in this case that I think the defense has to be careful and has to hit their highest and best points and not try to cram everything into a closing argument and turn it into disjointed, not able to follow it. I have a feeling the prosecutor is going to struggle with that too. You got to make sure you pick your best points. You give the jury the best things they can to hold on and go argue for your position back there when they're deliberating. But there's just so much to go on here for Karen Reed.
You would agree with me, based on those voicemails and what you know about them and what we just discussed, that no one at 34 Fairview, including Jennifer McCabe, could have witnessed Karen Reed outside that residence at 12:45 a.m., correct?
Somebody brought this up earlier. It's a good point. They all said they did see her then, looked out the window, saw the car so many times.
No, I don't believe so.
So you would agree with me? No one's...
State witness saying, no, I don't believe they could have seen her out there. They couldn't have seen her out there when they're the eyewitness of her car with connection with the key cycle and car data that shows reversing 60 feet at 24 miles an hour and hitting John O'Keefe at around 12:45. Folks, all of this information and evidence and testimony has come during the Commonwealth's case in chief. They have elicited this testimony, this inconsistent timeline. It's crazy to me. This is what stuck out to me today more than anything.
Could have, including Jennifer McCabe, could have seen her at 12:45 at 34 Fairview?
As I said, she auto connects to the Wi-Fi at 12:36, so no, she wouldn't have been there.
All right. Now, we've talked about the findings of, or the fact that you reviewed the findings of Rick Green by reading the affidavit that he submitted, correct?
Yes, sir.
And you learned in that affidavit that Rick Green was able to track not only when John O'Keefe arrived at 34 Fairview, but also the route that he and Ms. Reed took to get there on January 29th, correct?
I don't recall his report fully, but
You learned that he was able to accomplish that by examining the data from the app Waze that you spoke of, correct?
yes, I did find that myself.
All right. And Waze is spelled W-A-Z-E, correct?
Yes.
All right. And you've previously testified it's a commonly used app for driving directions and navigation.
Yes, sir.
And regarding your analysis of the phone, you learned that there was Apple Health data from John O'Keefe's phone on January 29th of 2022, correct?
That is correct.
And Apple Health data can reveal a number of steps that a person has taken during a given time period, as well as whether that person is going up or downstairs, correct?
Yes.
And on John O'Keefe's phone, you learned that there was Apple Health data that tracked his steps from the time he's seen on surveillance video leaving the Waterfall Bar and Grill and moving forward after that, correct?
I don't know anything about the Waterfall Bar video. I just have the timestamp from the phone showing it at around 12:12 at the Waterfall.
And it actually...
It's weird that he didn't look at the time that they left the Waterfall Bar and Grill. Again, like Murdoch, you could have traced all this with the combination of videos and his phone. You could have said, yeah, this is when he was at McCarthy's. He took this many steps to get here. But they want to say instead, step data is unreliable, which is fine. And a lot of you have said that too. But they could have lined it up with a lot more throughout the night with what they had with his movements on camera. And Karen, maybe they had their expert look at her 1:27 time. I don't know. But they seemed very confident about the time of her Google search.
Was between 12:11 and 9 seconds, and then the ending period of that first time period was 12:21 and 5 seconds. And then you...
Oh, yes, from the health. Thank you. Yes, sir.
Okay, from the Apple Health. And the data showed that he took a total of 170 steps between that time period, correct?
That's what the phone registered, yes.
All right. And regarding those 170 steps, isn't it true that this data from Apple Health signifies that 170 steps took place at some point during that 10-minute approximate time period?
No.
So is it your understanding that those 170 steps all took place at 12:11?
No. Again, like I said, the phone is a high-tech pedometer. It doesn't mean that steps were taken. It means the phone was manipulated in a way that it believed it was moving and taking steps.
Oh, I see your objection. Okay, so
Sorry.
Yeah, let's assume there were steps for the purpose of this discussion.
Yeah.
Okay, and they could have been steps, correct?
They could have been, yes. But
All right, so let's assume that for now.
Okay.
Assuming there were 170 steps taken, that could have meant that John O'Keefe took 170 steps beginning at 12:11 within that time period, correct?
It's saying that, again, the time frame that it gave me is 12:11 to 12:21.
Right. Yeah. So in other words, if he could have started walking at 12:11, correct?
Yes.
All right. But he also could have taken that 170 steps closer in time to 12:21, correct?
Well, at that point, he's in the car.
I'm not asking about where he was.
Could not have been, no.
I'm just asking about what the data shows.
And I would say no.
If it shows 170 steps between 12:11 and 12:21, then strictly based on the data, you don't know where those 170 steps took place within that 10 minutes, correct?
To a degree, yes.
And it's possible it could have been toward the beginning, toward the end, or maybe fairly evenly spaced, right? You just know that there were 170 steps that were taken in that 10-minute time frame, correct?
Again, that's assuming that they are steps.
Right. And again, I'm asking you from the data itself.
Again, the phone says it's steps, doesn't mean they are.
All right. Well, the Apple Health data also showed a total of 80 steps between 12:21 and 12:24.
Correct.
As part of your investigation of this case, were you aware that there was a 12:23 text message from Ryan Nagel to Julie Nagel in which Ryan texted his sister Julie he had arrived at 34 Fairview?
Objection.
Sustained. You can ask it differently.
And text investigation of this case, were you aware that there was a 12:23 text message from Ryan?
So now the defense is starting to line up their timeline. 12:23, car was there. Then how was he going up and down hills at 12:24? But instead, if at 12:23, Karen Reed had dropped him off, 12:24, was he ascending or descending stairs into a basement? I don't know. But you can see why the defense developed their theory. And it's up to the state to prove it did not happen the way the defense says it happened. Crime to solve it. I read every single one of these comments and I try to figure out what they say, even though sometimes they're jumbled. And I know it's not you guys typing it out, but there's lots of glitchy things that happen.
Ryan Nagel to Julie Nagel, in which Ryan texted his sister Julie he had arrived at 34 Fairview.
Objection.
Sustained. You can ask it differently.
In any case, you would agree with me that 12:23 is between 12:21 and 12:24, correct?
That is correct.
And that is the 12:21 to 12:24 time frame where the Apple Health data showed that the user of John O'Keefe's phone took 80 steps, correct?
Yes.
All right. Now, John O'Keefe's Apple Health data also showed that he climbed up or down 3 flights of stairs between 12:21 and 12:24, correct?
Yes.
And that's the same period in which the data reflects 80 steps, correct?
It's off by about 12 seconds. 12:22, 22. That's right. 12:24 and 22 seconds was the ending for the stamps, but 12:24 and 37 seconds.
Okay, but approximately.
Yeah. Approximately, yes.
All right. And regarding going up and down those 3 floors, Apple does not provide data precise enough to determine when within that range the 3 floors were transverse, correct?
No, there was a second point at 12:22 and 14 seconds that said specifically on stairs.
Okay, and you would agree with me that, and again, assuming that they were stairs as Apple Health data reflects, those stairs could have been ascended or descended toward the beginning, toward the end, or throughout that 3-minute time period, correct?
In this case, no, because there's a set point that's in the Cellbrite report that shows it's 12:22 and 14 seconds.
All right. Finally, his Apple Health data also showed a total of 36 steps between 12:31:56 and 12:32:16, correct?
Yes, that is correct.
All right. So I would like to direct your attention to your May 9th, 2023 report, which was the second report that you wrote that we've already referenced.
Yes, sir.
Specifically paragraph 15.
Okay.
You wrote that O'Keefe's health data in Cellbrite shows him ascending, descending 3 flights of stairs at 12:22 and 14 seconds. Did I read that accurately?
Yes, sir.
And the native locations in Cellbrite and the cached locations in Axiom both show O'Keefe's phone location by the intersection of Oakdale Road and Pinecone Road, which is in front of 36 Oakdale, and which is approximately a little over a half mile from 34 Fairview. Did I read that essentially correct?
Yes, sir.
All right. Do you stand by the statement that he ascended and descended 3 flights of stairs precisely at 12:22 and 14 seconds?
I'm going by what Cellbrite has given me from that time points, and that's what I used.
Isn't it true that what the Apple Health data actually state is that John O'Keefe's phone went up and down 3 flights of stairs sometime within the time period that began at 12:22:14 and ended at 12:24:37?
I can't speak to it. I don't know. This is what, again, I'm looking at the report. This is what the information that is parsed out of the phone is giving me.
Right. I'm just asking about the data itself. It gives you that time period and tells you 3 flights of stairs, correct?
Yes, that is correct.
All right. So assuming that those 3 flights of stairs were ascended or descended closer in time to 12:22:14, which was within that time period, that would still give him time to arrive at 34 Fairview within a couple minutes later, would it not?
I'm sorry, at the time.
Yeah, so we have a time period that you agreed with, which is 12:24:14, ending at 12:24:37, right? A little over a couple of minutes, like 2 minutes and 23 seconds?
Yeah, about that.
All right. So the 3 flights of stairs, again, just according to the data, could have been ascended or descended at the start of that time period, correct?
No. I'm confused what you're trying to say. So you're saying that he's at the house already at
I'm not asking
12:22?
about the house, I'm asking about the data.
No, I know, but I'm asking about when you're saying he arrives in that data range.
No, I'm
confused.
I'm strictly asking you just to look at the data.
Yeah.
And you agree with me, whenever there's a time period and Apple Health turns either steps or stairs, you can't pinpoint just from the data when they occurred within that time period, correct?
Objection. Your Honor.
The answer is like very clearly yes to this, especially from a guy that's already said they're unreliable. So I get Yanetti's frustration, but it also seems a little clunky on cross and not as, pointed and like they usually like to get in and out quick and hit their points.
Maybe helpful if counsel could refer to which data he's talking about and not just keep saying.
I'm
hearing his tape.
I thought that was
Do you
clear.
understand what Mr. Yanetti's referring to specifically?
I'm slightly confused. I know you said that time frame that I wrote in my report for that 12:21 to 12:24 And then, as I stated before, Celebrate shows a specific time point of 12:22 and 14 seconds when the stairs are ascended, descended. That's why I'm confused.
We're going to get to that, but
Okay.
I'm not asking you about that. I'm asking you about the fact that there's a time period and you can't place where within that time period, just based on that data itself.
That's what's recorded and shown to me. So again, that's what's shown. I can't say otherwise.
Your conclusion was that John O'Keefe could not have been at 34 Fairview Road at 12:22 and 14 seconds because Waze put him on Oakdale Road about a half mile away, correct?
Yes, correct.
All right. And that caused you to disregard the Apple Health data or to attribute it not to steps or to stairs because he was a half mile away between that 12:22 and 12:24 time period, correct?
Yes, I attribute it to movement.
All right. So I want you to assume for a moment, Trooper, that
So, Lori, do we think jurors could do this? Because usually I think you guys as the chat are pretty representative of potential jurors. And I'd be willing to bet it's possible. Sunday Girl, if they're just trying to get a DUI charge out of this trial, this would be the wildest and most expensive DUI trial ever. I had a DUI trial one time that lasted 5 days, which was insane. In one of the longest one, it wasn't a manslaughter case. It was just a DUI trial. 5 days and ended in a hung jury. And then eventually they dropped the DUI charge after the trial. But I mean, this would be the wildest DUI charge trial ever.
John O'Keefe's phone location actually showed him on Oakdale Road 3 minutes earlier at 12:19 a.m. Okay, you have that in mind?
You okay?
All right. With that assumption, would you agree with me that the Apple Health data about him taking 80 steps and climbing up or down 3 floors at 34 Fairview Road would make more sense?
Objection.
Sustained.
May we approach her? Sure. Sir, are you aware that apps on an iPhone may pull data from 3 different clocks when they're timestamping location data?
This was kind of wild to me. I didn't know that. I don't know that it's exactly how the defense says it, but it's interesting. And the Commonwealth is going to rehab it on redirect.
You mean like Mac absolute time or Apple
I'm
Color
asking
time?
you, are you aware?
Multiple timestamps that are in an iPhone, correct?
That's not my question. My question was, are you aware that an app on an iPhone may pull data by choosing from 3 different clocks when it timestamps location data?
Yes.
What are those 3 separate clocks?
Depends on the program. It could be Mac absolute time. It could be the Unix epoch time. And sorry, there's like 2 others. I don't remember them all off the top of
With
my head.
regard to John O'Keefe's actual iPhone, did you research what clocks were available for apps to pull data from?
No, I didn't.
Are you aware that those 3 clocks can vary in time?
Yes.
Oh,
Sometimes
really?
for a matter of seconds.
What do you mean? So
In other words, the 3 clocks could be seconds apart, correct?
I would have to see the data.
And you would agree with me that sometimes the clocks could be off by 3 minutes, correct?
No, again, I would have to see the data.
May I approach?
Yes. Mr. Lally, did you get a chance to look at that?
Directing your attention specifically to what is marked process 3434.
Okay.
In regard to the right side of that exhibit, you also see process 3434 with more information on the right side.
Yes.
And do you see the 3 different clocks that are listed on that printout?
I do.
What are those 3 different clocks?
So it's blurry monotonic date time, baseband date time, and then a display date time.
And looking at that, anybody, do you recognize that as being information that was available from John O'Keefe's phone from the extraction?
Yes.
I would offer that as an exhibit, Your Honor.
Any objections?
Regarding 3434.
Okay.
Or print out from John O'Keefe's phone.
Thank you.
Thank you. Now you have exhibit 640 in front of you, sir. Looking at 640, is it clear to you that those 3 clocks were not in sync regarding that one process number?
Yes.
In fact, the monotonic clock regarding this particular Waze artifact from John O'Keefe's phone says 2:22 a.m., while the baseband and display clocks have timestamps 3 minutes earlier, correct?
Yes.
So if there's a 3-minute difference between the clocks, well, strike that. Do you know, with regard to that 2:22 a.m. location data on Waze, do you know which clock Waze is using for that? Or the iPhone was using with Waze?
I don't. I didn't look through Action. I was using Cellbrite for that.
Okay. But certainly that would have been available to you had you looked at it, correct?
Well, this is the artifact you're showing me is from the power log. It has nothing to do with the GPS, so it's not correct.
You could have looked at that exhibit,
He said the power log, and we're going to get to that more on redirect. He explains it more.
right?
Yes,
The
and
information in that exhibit to see the 3 different clocks, sir?
Yes, but I can explain why this is incorrect.
All right, maybe Mr. Lally will ask you.
Sounds
All right?
good.
But you would agree with me if there's a 3-minute difference between the clocks and you don't know which clock was used to put John O'Keefe's phone on Oakdale Road at 2:22 a.m., that could explain Let me tell you. It's not 222.
No, I know what you meant.
Mr. Jackson, thank you. I'm sure everybody else did. With regard to the 3-minute discrepancy between the clocks, and you said you don't know which clock Waze was using to put John O'Keefe's phone on Oakdale Road at 12:22 a.m. That could explain the discrepancy between the Apple Health data and the Waze data, could it not?
No.
But
So you get what the defense is trying to show there, that all of these times could be off 2 or 3 minutes. Of course, absolutely not. Not in this context. The data could not be wrong like that. Okay. So they get into the 227, how long to die in the cold. He says it didn't happen at 227. It was just 623, 624. Yannetti brings up the point that somebody else brought up earlier, that he skipped 40 pages of text messages between Karen Reed and John O'Keefe, which I assume we're going to hear more from later. He asked how many calls or texts were deleted from Karen Reed's phone, 0. But then when he got into this territory, again, I did not love this near the end of Cross. I think it was the end of Cross, about Google searches and did she delete Google searches? I think it came off clunky. Potentially the evidence came off incorrect. And I was nervous, like, did they open the door to this now? Or I should say, is Bev going to say they opened the door to it? Because there's no way you should open the door to asking for a lawyer. But they do talk Google searches, and we've seen judges reach sometimes for open doors.
between 12 a.m. and 4:30 a.m. on January 29th.
Her parents twice. There 2 or 3 times there's calls to her parents, and that's it.
And how many Google searches did she do from 12 a.m. until?
I think he was a little nervous when he started it even. He stuttered, stumbled over it a little bit, because you got to be careful when the judge warns you not to open a door.
5 a.m.
I don't believe there were any.
And how many Google searches were deleted by Ms. Reed at any point on January 29th of 2022?
I can't speak to that because we got a redacted version of the report, so I don't know what was taken out by the AG's office. I don't know what files they went in to remove, so I only have what I was given.
Leaving that aside, sir, with regard to all of the data that was provided to you, how many Google searches did you see or find that Karen Reed deleted from January 29th of 2022?
A few.
During what time period?
The after.
It's not great. This is not a great ending, because she did delete a few now. Why did we get that out? The state never even brought that up. So now we're getting out that Karen Reed's deleting Google searches. And did she actually delete them? Or is it like the Jen McCabe not real delete? It was not a great ending to Cross.
Afternoon. But again, there was artifacts that I found that weren't date timestamps, and there were some that were with corresponding timestamps, but I can't say for sure when that was done.
Okay. But you.
So that's basically the end of Cross. Then we get into redirect. Lally said, it wasn't Proctor manipulating the phone or anything like that. Doesn't know who found the phone. This guy was basically at a conference, and he asked the guy for help because he knew the data wasn't how it was supposed to be, or didn't look the way that it was supposed to look. So some guy at a conference helped him, and that's kind of how they cracked it. And then he does explain the timestamp discrepancy, which I thought was interesting, and I think makes sense and pushes back on the whole 2 or 3 minute. But again, the defense is throwing a lot up against the wall. So the Commonwealth is constantly having to disprove these theories. And there's a lot to work with there for the defense. So it makes the job very hard for the Commonwealth.
So when I looked at that, that also shows the battery level. And that's how I was able to show that, or see, I should say, that John O'Keefe's phone never turned off. It dropped down to about 17% battery level. From being under his body, it was actually saved it from dying overnight. Then it also shows the timestamps of when it gets plugged in and as it goes up. That has 3 different timestamps. That's what that is from. That is not when Waze is started. That is not when the address is put in. That is strictly for the power log. There's nothing to do with anything else.
And so, to that point, what if any connection to those timestamps in the document marked for identification Mr. Yannetti showed you, what if any relationship does that have to the timestamps contained within either the Waze or GPS native locations or anything else that you were testifying about before?
It's literally showing that Waze has been opened and that it's pulling power from the phone, and that is it. There's nothing else.
Now, with regard to, you were asking questions about Ms. McCabe signing consent for extraction on February 2nd, 2022, correct?
Yes.
And Ms. Kerry Roberts, she did the same on the same date. Is that also correct?
All right. So he says it's showing when the charge of the phone, power up, power down, things like that. Makes sense. Makes sense. I think the jury will be able to figure that out from the actual report. Trying to think if there's anything else. Confirmed a search deleted by Karen Reed. His opinion is that McCabe's search happened between 6:23 and 6:27, or not 2:27. All right. So that's the end of this witness. It was the biggest one, but we still have 2 more to get to. Here's what I want you to do, though. Hit the like button if you guys haven't already. 19,000 people in here, including, across all the platforms. Hit the like button and make sure you subscribe. or follow whatever social media channel you're on. I love all of the new people that come and join us from the trial, especially the locals from the trial. Give us the local feel and the local buzz of what people are thinking and what people are doing. I'm going to hit a few questions, and then we're going to get to Dr. Stonebridge, I think her name is, Stephanie. But if you had an Apple Watch, the health data is telling you about the person's movement versus the phones. That's what this cop is saying, but I've heard people argue with the Apple Watch data as well, like the Daybell case. When? Do you have an opinion on all KRJO info is correct or can be made correct, but everyone else has glitches with no explanation other than the phone did it? Can't wait for the defense experts. Yeah, and it doesn't seem like Karen Reed or John O'Keefe butt dialed anybody. We haven't heard anybody say that yet. Yobi, can I claim the super chats as tax write-offs? Do you need continuing legal education? Just kidding. Not a tax attorney, not a tax expert. You should consult with a tax expert with that question. It's a great question. Bethany, do you think they brought this to trial just to keep everyone else safe? Because even if she's found not guilty, they usually won't try to charge anyone else. I don't know. I don't know what to think. I honestly don't know what to think. Sue, do experts need to show proof before testimony? So they usually have a report. They have to clear the Daubert standard. It has to be reliable, peer-reviewed sometimes, generally accepted. It has to aid the trier of fact in a way that they can't just understand it on their own. So there are checks and balances, Daubert, Fry, different standards in different jurisdictions. Yes, they can't just come spout junk science for the most part. Mego, wasn't the Commonwealth's point that she searched for a DUI lawyer before Canton PD engaged her? Emily Baker thought Proctor called her a few minutes before the Google search, but the prosecution didn't mention that. Prosecutor didn't mention it. Yannetti mentioned it, and it seemed like he had a call log from Proctor's personal cell phone that he did call her at 1:19. Regardless, we didn't get too deep into the arguments because Bev said no. Waldo, as of right now, should she take the stand? My advice would be no, but her lawyers know the case better than I do, so I would trust her to listen to her lawyers. Why is the timestamp on Karen's Google search all of a sudden accurate, but Jen McCabe's wasn't? Nikki, when voting for judges locally, I'm in Arizona, it's hard to research on those that we should vote for unless they are in the media. Any advice what to look for? Yes. Do you know a lawyer? If you know a lawyer or a couple lawyers that you trust, ask them, number one. Number two, you can do some of the research yourself. And then number three, sometimes they'll have round tables or events that they'll talk at that you can actually ask questions to. You can research cases they've done and stuff like that. Sometimes that's harder. Do you know anybody that works at the courthouse? Maybe you can get some information there. Anybody that works in the legal field that you trust, that's where I'd get most information. A lot of people ask me locally, and I love to share that stuff. Liz, Peter, have any of your trials been streamed? No. Local CCTV, when I was a prosecutor, they were streamed to the interior of the prosecutor's office. And now that I'm doing a lot of wrongful death, personal injury, car accident, truck accident work, most people don't want that stuff streamed. There's medical business out there and all of that. So, and I would never push for a trial to get streamed. If it happens one day, that'd be really cool, but I don't necessarily expect it. Christy, Peter, in your opinion, as of today, what would you argue to the jury as the best evidence of reasonable doubt? Oh, Christy, there's so much. The timeline, the lack of accident reconstruction, none of it makes sense or lines up with where the pieces went. The medical information that we're about to get to, I think, is a big one as well. So we'll hold some of that. Sparkle, hi, Peter. Did I hear him wrong that he determined the strength of the GPS accuracy in May, so not during a snowstorm? I might have missed that if he did say that, Sparkle. Sorry. Brian P. Surprised no one used a demonstrative to map out the timelines for the jury. Maybe it's coming in closing. Usually, prosecutors only do that if it helps them. I don't see how they could create a timeline in this case that helps them, honestly. Maybe the defense will. We'll see. Christopher, we still don't have an answer to the question, how does a car hit someone with enough force to break a taillight but leave no bruises on the body? Well, that's a good transition into these medical experts. Let's take a listen. First, we go through the background and experience of Dr. Stonebridge, explains acute versus chronic injuries. John O'Keefe's injuries were obviously acute, occurred in minutes to hours prior to them finding him. A lot of blood vessels ruptured, causing the contusions, explaining, she explains these injuries in a way that's fine, not incredibly helpful to either side, in my opinion. But here's kind of the end of her testimony. And by the way, there was no cross-examination, which tells you what the defense thinks of it, and nothing she really said hurt them. I kind of agree with that. She just kind of explained the injuries that we all agree with. And we'll listen to the last couple minutes of her testimony here.
Due to some type of trauma.
If I could ask, as far as you have certain findings as far as an intraventricular hemorrhage and occipital forms of the lateral ventricles, correct?
Yes.
If you could please explain to the jury what exactly does that mean?
Yes. So the ventricles are almost like a fluid that nourishes the brain. So the cerebral spinal fluid serves as a fluid that nourishes the brain. It provides a flow of nutrients, oxygen, things like that. And it starts in the frontal portion of the brain, and then it goes backwards towards the occipital, which is the back. And it also flows downward through the brainstem and then into the spinal cord as well. So the occipital horns of the lateral ventricles are in the back of the head, and having hemorrhage in those areas, in any area of the ventricular system, is usually indicative of some type of trauma. So there should not be blood freely flowing within the ventricular system.
Now, Dr. Stonebridge, with regard to your findings, you mentioned that your findings were that the injuries were acute and that the injuries were the result of trauma, correct?
Yes.
What, if anything, can you say or can you opine as to the mechanism for those acute traumatic injuries?
It was something that required some type of force, given that there were skull fractures. I can't say what type of force or how much force, but it was definitely something that caused some type of force, which led to the skull fractures and then the subsequent brain findings.
And the brain findings in particular that you made, were those consistent with the fall?
They can be, yes.
Can they also be consistent with being struck by a vehicle and then going to the ground?
Yes, they can be.
So, some serious force. We don't know exactly how much. They can be consistent with a fall. They can be consistent with getting hit by a vehicle and falling. So, she says yes. What's interesting, so no cross. I may have gotten up and said, did you measure how high on John O'Keefe these injuries were? They said he measured 6'1", 217. Did you measure how high the injuries were? And if she says yes, 6 feet or 6'1", or at the top of his head or bottom of his head, whatever. If she says no, then I would say, did you measure on the car where any damage to the car was? And when she says no, I would say, would you expect to see damage on the car where the blunt force trauma hit in the head? And if she said no, because his head could have hit the ground, I would say, well, wouldn't you have expected to see that somewhere on his body? I would have asked her those questions. She probably would have said no, or she didn't know, or whatever. But to say it could be consistent with it getting hit by a car, sure. Any blunt force trauma could. But we have more information than just hit by a car. We have damage to the car that either does or does not line up. And that's the important part. Sure, these injuries could have happened with a car. I was thinking more like if he was like bending down and tying his shoe and then boom, the bumper hit him right in the head, it could cause some serious blunt force trauma. If she did hit him in the body and he flew and landed or dragged under the car, there's lots of ways that I think these injuries could have been caused by a car accident. I just would expect to see other injuries as well. So that's basically all I'm going to play from this witness. I'm going to hit a couple more questions and then we'll get to the last witness. Hour and a half. Holy cow. All right, let's get through some questions. Is Cross usually so spicy with officers? This officer oddly editorializing and laughing felt off. I agree. I don't like to make light of anything in very serious cases like this. There are sometimes Cross can get spicy with experts, and every lawyer has a bit of a different vibe and feel. So it depends on the lawyer and the officer. Steve, do you think it's possible for everyone in the house to fall in line with the Albert story? No. Or maybe the friends of Junior didn't see O'Keefe come in. I think he went in. If there is a big conspiracy, I think there's a lot of unknowing participants. Michelle, do you think that the juries ever decide on guilty verdicts only for the sake of giving the victim's family justice, even when the facts are on the line? I think it comes into play. I'm not going to say they do it just because of that. Thoughts on the Emmy about his injuries? No fight. We're about to get there, Ashley. Hannah, if the ER dog bite expert says to a question, what's your conclusion with my dog bites and car accident? It's more reasonable it was a dog. Could the prosecution strike it? Probably, but the bell would already be rung. Am I missing something, or is there a 3-minute discrepancy from Waze data and complete bombshell? It makes the data fit together way more cohesively. If you believe that it can be off by a few minutes, then yes. Why would Yannetti mention Steve Scanlon in his opening if he wouldn't testify or sign an affidavit? So this is outside my purview. I don't know who Steve Scanlon is. I don't know if he's going to testify. I don't know if he's not. I'm not sure. Tim said Daubert should have a conversation with Trooper Paul. That's a good one. Arizona, did they try to access the dog from the new owner. They didn't know that dog existed with a new owner till this trial, at least how it seemed. Michelle, Peter, if she hit him and the taillight pieces were in the road, couldn't the plow that went by have moved them prior to his body being found? Yes, I guess. And if that's true, the Commonwealth should have told us, right? All right. So now let's get to Dr. Scorabello or something. Medical examiner, good experience, education. Point of the autopsy is to determine cause and manner of death, explains the different manners of death. And then we get into what does undetermined actually mean. And to me, the unfortunate part for Lally and the Commonwealth is I think the jury thinks undetermined is bad for them, regardless of what this medical examiner is going to say. And I think after her testimony, they could have had a good argument. Undetermined is fine for them. But because of Proctor and his convo with the boys in a rookie move, I think that the jury's going to think this is not good for them.
Death to themselves. So most hangings, intentional, I'm sorry. And then we have one more manner that we call undetermined. Some jurisdictions, they call it could not be determined. That means that evidence pointing towards one set of circumstances or one manner is no more compelling than evidence pointing towards another manner of death. So if we don't have enough information to know whether something, or to be able to determine the circumstances, then we are left with an undetermined manner of death.
Now, am I correct in stating that the cause of death is something that's more like a medical determination? Is that correct?
Yes, the cause.
So watch the leading questions, Mr. Lally. It's the same.
How would you characterize the determination that you make in regard to a cause of death?
The cause of death is based on my findings at the time of autopsy, along with any medical information that I may have on that deceased individual.
Now, as far as the manner of death, how are you making that determination?
The manner of death, as I mentioned, is circumstance dependent. I make that determination based on investigative information that is provided to me by law enforcement, by the people who did the investigation.
And what, if any, legal determination are you making as far as when you classify something as either of those five categories in a manner of death?
I am not making a legal determination. I'm making a medical determination.
And so as far as the medical determination is manner of death, specifically when I'm talking about something that could be ruled or listed as manner of death as accident, is that, what if anything, what if any determination are you making as far as that is concerned?
I'm making the determination that the information that I have either shows no evidence or very little evidence that the injury that led to the cause of death was intentional. So I don't have any information to suggest that that was an intentional act.
And am I correct in saying that routine?
It would be really hard, I think, for her to do that in this situation, or if somebody was hit by a car, it would be really hard for her to say that it was intentional. And so that's not really that unusual under the circumstances, but Proctor screwed the pooch on this one. Like, he's the one that made this seem bad, in my opinion.
People charged with, say, more of the homicides, it gets classified as a manner of death as accident, correct?
Objection. Sustained.
May I approach on?
Yes.
But that actually is true, I believe.
And Doctor,
I do.
and what do you recognize that to be?
This is a copy of the death certificate for Mr. John O'Keefe.
That's signed by yourself, is that correct?
Correct.
And as far as the listing related to cause of death, what did you list as cause of death on Mr. O'Keefe with regard to his death certificate?
Cause of death was blunt impact injuries of head and hypothermia.
And with reference to manner of death, what, if anything, did you list on Mr. O'Keefe's death certificate in relation to manner?
I listed could not be determined.
And as far as that listing for could not be determined, if you could explain to the jury why it was that you have that listed as manner of death with relation to Mr. O'Keefe.
Again, the cause of death is something that I can determine by the autopsy. I did the autopsy on Mr. O'Keefe and determined that he had injuries to his head as well as signs of hypothermia. So the combination of those two was the cause of death. The manner of death has to do with the circumstances under which Mr. O'Keefe sustained those injuries. And I did not have enough information to be able to determine whether those injuries were accidental or not. And so my manner of death was undetermined or could not be determined.
And just from the spectrum that you had just talked about, sort of the five different manners of death, fair to say that you did not determine that this was either suicide or natural causes, correct?
Correct.
And so as far as your determination of manner of death being could not be determined, which of the two were you sort of in between?
The two manners of death that remain are accident and homicide.
Now, may I approach?
Yes.
You had made reference as far as cause of death being a blunt force injury. Is that correct?
Correct.
At least one of the contributing causes. If you could explain to the jury sort of what you understand that to mean as far as what is a blunt blunt force injury?
Blunt force injuries are caused by any blunt object. That is a very big category of objects. A microphone could be a blunt object. This bottle, if heavy enough, could be a blunt object. The ground can be a blunt object. So anything.
Basically anything that's not sharp. So it's like, again, blunt force trauma is not exactly the most specific finding. Undetermined is not exactly the most specific finding. So these medical experts are not doing much to further the case with most of their testimony. Now, at the end, she does help, and we're going to get there. But like a lot of this, it's like, we know it's bad. We've heard what the pictures look like. We've heard the explanation of the injuries and what he looked like that night. We know the blunt force trauma is bad. Nobody is saying it's not.
That doesn't have a sharp edge or a razor edge, not a knife, not a scalpel, is a blunt object. Blunt impact injuries are categorized into contusions, which are bruises, abrasions, which are scratches, fractures, which are a break in the bone, and lacerations, which are tears in the skin. So when we say blunt impact injuries, we could be referring to any of those or a combination of those four types. And all those are the result of impact of the body with a blunt object.
Now, we'll get more into specifics in a moment, just in general terms, as far as from your external examination of Mr. O'Keefe's body, whereabouts sort of geographically on the body did you observe these blunt force injuries?
The majority of the blunt force injuries were to the face and the head, as well as to the upper extremities, the arms.
Now, starting with Mr. O'Keefe's head, what was it specifically, or where was it that you observed blunt force injuries to Mr. O'Keefe's head?
Okay. I observed a number of different injuries on Mr. O'Keefe's head, starting with his eyes. He had hemorrhage or bleeding on the upper eyelids of both eyes, as well as swelling of the eyes. He had a small laceration, a small tear in the skin on the right eyelid, again associated with the bleeding. He had some abrasions. Abrasions are superficial scratches on the skin on the left side of his nose, I believe. And when I looked at the back of Mr. O'Keefe's head, he had a laceration, as a tear in the skin that was surrounded, or it was associated with an abrasion, as a scrape.
Now, in terms of the extremities, and I'll start with upper extremities as far as his arms, what, if anything, did you observe in regard to blunt impact injuries to his arms?
He had, on the right upper extremity, he had a number of somewhat linear, somewhat patterned abrasions, scrapes, varying sizes.
Interesting to hear her describe this stuff. I liked her testimony, actually, as somebody who's interested in medicine and deals with a lot of injuries in my case, wanted to be a doctor once upon a time. I enjoyed her testimony. I know a lot of you did as well. I don't necessarily know that it helped to prove much, except for a couple important points we are going to point out. But I think she's about done. We're going to listen to her explain these scrapes, which are interesting, and then we'll get to some more of her testimony.
Sizes, ranging from small, 2 to 3 millimeters to, I believe, 5 or 6 centimeters, both on the upper arm and part of his forearm. He had some contusions or some bruising on the dorsal aspect of the right hand that I measured and documented. He had he had a very small abrasion, I believe, on the lower extremities near the right knee, but I would have to look at my notes to be absolutely.
She focuses on and talks about how the skull fractures to the front and back of his head were from blunt force objects, and they were very extensive. Okay. Then a couple times she would say something where I was like, wow, this is interesting. And one of them was when she said he had some small hemorrhages in his stomach. And she explains what those small hemorrhages are from and what they indicate, what they're indicative of.
Examination was concerned with regard to Mr. O'Keefe. Starting with his stomach, what, if anything, did you observe of any significance in that area?
I observed that there were some small hemorrhages, small areas of bleeding in Mr. O'Keefe's stomach.
And are those described in medical literature as a specific type of spot?
They have a name. They're called Wisniewski spots, Wischnewski, and they have been associated with cases of hypothermia.
And how so? How have they been associated with?
So these hemorrhages, I thought they were going to be an internal injury to the trunk, which is what I would expect in a car accident case. But instead, they are associated with hypothermia, and she's going to explain how.
Cases of hypothermia.
They have been seen in cases of hypothermia. It's one of the findings that supports the diagnosis of hypothermia. They are not always there, and their presence doesn't definitively diagnose hypothermia, but they are one of the findings that, if present, suggest the diagnosis of hypothermia.
And based on your training and experience, based on other types of literature that you've reviewed in regard to hypothermia, what is, as far as these Wisniewski spots?
So she talks about how hypothermia can affect the death, even if it's not the main cause. In this situation, she thinks these were non-fatal injuries at first, and hypothermia either accelerated or added to the cause of death. She talked about the toxicology report for John O'Keefe. Blood alcohol level was a 0.21. And then the other one, vitreous or whatever it is 0.28. So like drunk is what it sounded like to me. And that's consistent with the Commonwealth, who has asked these other people, are they drink for drink with each other? John had this many drinks. Karen had this many drinks. So kind of by comparison, I think that's helpful to the Commonwealth, that his was so high. Then she explains something that I thought this was a very important part for the Commonwealth. And I figured this was coming because I had heard this from some people already. And in some of our cases, we've talked about how the black eyes or raccoon eyes can actually be pooling of the blood from trauma to the back of the skull or a different part of the head. So I think she explains that, and that's huge to give another explanation as to why, the defense says he looked like he went 10 rounds with Mike Tyson or whatever. This was an important explanation. This was one of the key moments of her testimony for the Commonwealth.
You could expound upon, when you use the term ecchymosis, what exactly does that mean in specific reference to the area of the eyes?
Ecchymoses are a word that we use to describe bruising.
So before we get there, Lisa, so I have a buddy and we play fantasy football, and, sometimes we like co-manage a team together just for fun. We argue with each other. We should do this trade or pick this guy up, whatever. And one of our favorite lines to each other is, if you squint, we think he could be really good. And it's like, we probably shouldn't trade for guys. You got to squint to see if they're good. And that's exactly what you are saying in this quote. Made me laugh when I read it.
Orbital ecchymoses or periorbital ecchymoses or supraorbital ecchymoses just refer to the location of the bleeding in relation to the eye. And when we see ecchymoses or bleeding around the eyes, one of the differential diagnoses, one of the etiologies is blunt trauma to the head, and specifically fractures to what is known as the base of the skull. And
so it doesn't have to be you've been punched in the eye to have that look of the eye, the swelling and the black and blue eye like John O'Keefe had. Another differential diagnosis is blunt force trauma to the head or a fractured skull, which the Commonwealth's arguing that's exactly what happened here. He wasn't beat up. He wasn't in a fight. Instead, it's blunt force trauma to the head, either from colliding with the car or his head hitting the ground. So I thought this is important for the Commonwealth.
What you're seeing here is the base of the skull.
Now, Doctor, if you could, using that diagram up on the screen, explain to the jury, what we asked first, as far as were you able to formulate an opinion to a reasonable degree of medical certainty as to how the injuries within the skull and the brain interacted with each other, in particular interacted also with the ecchymoses that you described in your origin?
So the injuries inside the skull, this is the base of the skull. This is, think of it as the tray where the brain would be sitting on top. The brain has been removed, and now we're looking at the bones. Right here is where I noted the skull, one of the skull fractures to be originating or starting with fractures. These are linear fractures that are extending or radiating from this one point of impact. This is known as the posterior fossa of the base. These two chambers are known as the middle cranial fossa, and this would be thin and friable. So an impact to the back of the head was in this case, because we do have a laceration and we do have an abrasion. So we know that the head impacted something blunt with enough force to break the skull and enough force for those fractures to propagate or radiate into the middle cranial fossa and also the anterior cranial fossa, which is
So nobody argues with that there is that blunt force trauma to the back of the head, but the defense would definitely have you believe the injuries to the front of his face are from punches and, whatever, getting into a fight. Now, one of the times she explained this, she did say there was a cut or a laceration. We know there are some of that on the front of his face. Is that from hitting the car? Is that from being punched? We don't know. But I do think that this is important, a plausible medical explanation for why John O'Keefe looked like he did that night.
front chambers of the base. When the anterior cranial fossa are fractured, as I mentioned, they are very thin bones. Blood can seep from this area into the soft tissues and manifest as hemorrhage or bleeding or a contusion or an ecchymosis around the eye when you look at the person's face, even when you look at their face. So it is a well-known fact that fractures to the base of the skull can present with orbital ecchymosis, and that particular manifestation has a name. It's called raccoon eye because it resembles, I guess, what raccoon eyes look like. But emergency room physicians are always very alerted to any hemorrhage and any bleeding around the eyes, because it could signify or it could mean that there's a much bigger injury inside the skull, and that is not just some bleeding around the eyes, that it actually is associated with a skull fracture.
And it also makes sense. She talks about how the brain wants to swell. There's not a lot of spots for it to swell with the skull. The eyes make sense, right? With the holes in the skull. Randall, Peter, what does the K on her you'll see stand for? So this is the other doctor witness. I have literally no idea. But a lot of people ask questions like this. D-Rock, are there regulations on attire for testifying? People have asked if I tell experts what to testify. Usually I don't for experts. Our client is one thing. Maybe our client's family members, if they ask. Usually not with experts. You would expect them to dress appropriately. I didn't really have a problem with how she was dressed. Maybe 10, 15, 20 years ago, people would be offended with tattoos and stuff. I think it's pretty normalized today. But I don't know. You guys can tell me, would you be offended if you were on the jury? Susan, why can these medical experts read directly from their reports? I didn't notice that they were doing that. I thought experts usually have to go off memory. So you can always reference your report and refresh your recollection with your report. I didn't notice them reading off of their reports, but I also usually listen, and I don't always watch everything. Were dog tracks found in the front yard? No. In fact, Lally asked somebody today if it was disrupted in the front yard. Were there footsteps or anything that showed a body was dragged? And the answer was no. Olivia, can the defense on cross ask the Emmy if she knows the lead detective called her a whack job? I don't think so. I don't know how you'd get that in. I don't know how that's relevant. Maybe were you pressured by Proctor to do a certain thing, or do cops ever pressure you to give a, homicide, manner of death, things like that? Maybe questions like that. I don't think they're going to be able to get into Proctor's specific texts that she wouldn't know about or would have seen. So it's outside the scope of her knowledge, really. I'm a little behind, but if there is a court reporter for trial transcripts, what do the judges do with their notes that they take? Thank you for all you do. And first super chat too. A lot of people first super chats today. Pumped, all these people getting involved in the channel is awesome. Usually judges' notes are their own. And they just make them to keep track of the trial, to make decisions. Sometimes they'll reference them in sentencing and things like that, but they don't become part of the court file. Kim, CT Tech here, seen hundreds of MVA pedestrians struck victims. They have an apparent damage to torso and broken dislocated bones, damaged organs. The arm abrasions are definitely sus. Why no frostbite, blood loss? A lot of unanswerable questions that I would hope experts, medically and stuff would be able to answer in this case. Dewana, what would you focus on with these testimonies? I would focus on that they don't know how these injuries happened, how they can't explain how a car hitting somebody could make it look like this. They can't explain why there's no injuries to his torso. They can't explain what they don't know and aren't saying. I might highlight that, because what they are saying, for the most part, the defense agrees with it. Again, besides this raccoon eyes theory, that's not good for the defense. All right. Next, we'll hear how they answer when the prosecutor asked how much force would it take to cause this kind of an injury.
May I approach this with you?
We're almost done.
Doctor, with respect to the head injury specifically the fracture, what, if any, opinion can you give or can you say in regard to the type of force or amount of force necessary to cause the fracture to the skull that you observed with regard to Mr. O'Keefe?
I can't really give you a number. I'm not a physicist. I can tell you that the skull is a pretty thick bone. It takes considerable amount of force to fracture the skull. So that was a pretty considerable impact.
Now, with respect
to let other experts do that, but will the judge let other experts do that? But she said significant impact, which again, I think everybody would agree with in this trial.
to the injuries to Mr. O'Keefe's head and the onset of hypothermia, what, if any, opinion do you have with regard to the timing of those respective to each other?
Well, I do believe the injuries, the blunt impact injuries were sustained first. These are not injuries that are immediately lethal. This is not something that would cause death in seconds. And therefore, Mr. O'Keefe may have been incapacitated by the injuries or knocked out, if you will, and was not able to get himself into a warmer environment, and therefore hypothermia set in, given the environmental conditions and given the clothing on the body, or the lack of clothing, I should say, no big jacket or anything like that.
Now, when you say something as far as some type of injury being immediately lethal, can you give an example of that?
The one that forensic pathologists like to use is a gunshot wound to the head.
All right. Rebecca, I think this is a good point. Not for the open lacerations to the eyes. Right. I agree. And I don't think that's what she was saying necessarily. But while she was explaining it, she did mention that while the eyes were swelling. So I guess technically it's possible too. Or like I said, I never know what this is, a capital I think. To me, this is the story of the Commonwealth case. Plausible. Plausible black eyes aren't from the direct trauma. Plausible house long search wasn't done at 2:30, right? And plausible is not enough to prove it beyond a reasonable doubt, right? It was snowing, so footprints would be covered up, of course. But still, the question can be asked, and everybody that was there was no disruption that they could see, right? So it's technically also true, even though, again, might not be very helpful. Peter, I know she's a prosecution witness. Do you think her testimony helps the prosecutor or the defense? Thanks. Well, generally, I think it's just true testimony, but there were a couple points, one we already played, and this one that I think were very important for the prosecution.
Now, from your extent of your examination of Mr. O'Keefe's body, what, if anything, that you observe that would indicate any sort of altercation or a fight or anything like that Mr. O'Keefe was in?
I didn't see any major signs of what I would call a significant altercation.
I didn't see any signs / major signs. And she also closed her eyes when she said that, which I thought was interesting. She just looked nervous, I would say.
That would indicate any sort of altercation or a fight or anything like that Mr. O'Keefe was in?
I didn't see any major signs of what I would call a significant altercation.
And
why she would be able to testify to this, but the other doctor wouldn't, is surprising to me. Because I wonder who has more experience, a medical examiner or an ER doctor treating people that have gotten in car accidents, fights, and dog bites. I think I might guess an ER doctor, right?
With regard to that, as far as signs, what are some of the signs and what would you be expecting to see and what was lacking as far as your observations of Mr. O'Keefe?
I looked at Mr. O'Keefe's hands. As you saw on the diagrams, I did document that there were some contusions on the dorsal aspect, very vague and faint contusion on the left and contusion on the right hand. That particular contusion has a central little pinpoint mark that may suggest that it was due to attempts to get IV access on his hand. That's a very common place.
So she's saying there's not bruising on the hands like he was punching somebody. Instead, it was trying to get an IV in.
But I didn't see any bruising on Mr. O'Keefe's knuckles. His nails were intact. I didn't see any breaks on his nails, and I didn't see any fractures or feel any fractures on any of his hands.
Now, with respect to diagrams that were up on the screen before, as well as your observations from internal examination, you observed some fractures to Mr. O'Keefe's ribs, is that correct?
Yes, he did have some fractures, I believe, to the 4th and 5th ribs near the sternum.
So again, I was like, oh, fractured ribs? Why haven't we heard anything about this? That makes a lot more sense, right? Blunt force trauma, if he landed on his front or was hit in the front, you could fracture some ribs. And was there bruising around it? Yeah, a lot of people are saying kind of, it could have just been a slip and fall, which is true, but that's not what the defense is saying happened, right? And that's the interesting part about picking a specific theory and going with it, as opposed to just there's a lot of theories that could have happened, which I think could have been a really good defense in this case too. Chance, because he was much bigger than her, he would have to drink more alcohol for them to have similar BAC. Being that intoxicated would make it easier for someone to jump him in a fight and him not fight back very well. Or, as a couple of the other comments said, more likely that he slipped and fell. Could that backfire? Will the jury start to think maybe he was just drunk and he fell and nobody hit him?
It's a very common location for CPR-associated fractures.
And so
It wasn't fractures from the, sorry, I answered questions in between my comment. So it wasn't from getting hit by the car. Instead, what are those rib fractures from? I'll let her explain it again.
Some fractures, I believe, to the 4th and 5th ribs near the sternum. It's a very common location for CPR-associated fractures.
And so I believe you just alluded to it right there, but as far as any fractures to Mr. O'Keefe's ribs, what, if any, opinion do you have as to the origination or causality of those rib fractures?
As I mentioned, those are very consistent with the resuscitation. We see those quite often, given the history that I was provided that extensive resuscitation was attempted. I documented those as most likely due to resuscitation.
Now, doctor, with regard to the...
So those fractures were from CPR, basically.
Just by way of contrast, you talked a bit about the significant impact or the thickness of the skull. How does that relate to the area of the ribs that you're talking about as far as can be fractured in resuscitative efforts?
Well, I don't understand the question.
Let me rephrase. What is the difference sort of between the thickness of the bone in the skull versus the thickness of the bone in the ribs?
The skull in general is a thicker bone. It requires more force.
Right. So more blunt force trauma to, in fact, bust the skull than to break the ribs. All right. Finally, we got through it. It took a little longer than I was expecting, but important testimony today, and I think we're winding down. I have heard she's the last Commonwealth witness. I have heard they're going to be done tomorrow morning, and the defense is going to start their case in chief. It is no longer a half day on Friday, like it was originally believed to be. They are going to go a full day. And people sent me a Yannetti clip that he said the case is going to be to the jury next week. So maybe it'll be less than 4 days. Maybe it'll be to the jury. I'm going on vacation on Thursday, but I'll still stream. I'll bring my stuff. I'll bring my portable set if we've got a verdict or closing arguments or something, and we're still going to hang out and we're still going to talk. It's just chill. We're going to a hotel with Witt's family to just chill and go to the pool, play some golf. Need to get my golf swing in order. I got a week. Nietzsche, if Karen tells her attorney she's guilty, can they still defend her at all costs because of privilege? Yes. Or must they recuse themselves due to ethical conflicts? No. They can't put her up on the stand and let her knowingly lie or ask her questions they know she's going to lie to, but you can still force the Commonwealth or the state or the prosecutor to prove the case beyond a reasonable doubt against your client, even if they tell you that they are guilty. Lorna, are multiple theories allowed, example, fall or fight for the defense? Yes. Anything other than what the Commonwealth is saying, the defense can argue. For the Commonwealth, they got to prove to us what happened. It can't be an accidental fall and second-degree murder. Rebecca, rib fracture common with CPR. Yeah, I mean, I have heard that before. I thought it was interesting that she said that. Also, Rebecca, slow death can happen in hypothermia, which is why we put patients in a hypothermic environment, protects the brain, and correct answer is ER doctor knows more than you, or knows more than the medical examiner. Thank you, Peter, for your coverage. Yeah, I mean, that's what I would think. Guess what? 90% of my cases that aren't wrongful death cases have seen an ER doctor, right? And most of them don't see medical examiners. Not all car accidents are deaths, but a lot of car accidents go to the ER and get treated and have injuries that are consistent with car accidents. KK, and that bubble for the iPhone 1 means nothing. The bubble is so big, it has me at my neighbor's house, surely covered the back door of the Alberts. I agree, and I felt the same thing. That's why they were trying to say, sometimes it blew up and sometimes it's small. All right, I'm going to hit a couple more and then I'm out of here. Peter, Dr. Shabella seemed to me that she was not feeling great. Maybe that was the case. I'm not sure. P, why wouldn't the defense go with multiple theories? They think they know the true theory and they think all the evidence points to that theory, I guess. I don't know. They decided to go for it. Was it because they knew the media was involved and people would jump on that? I don't know. D-Rock, if you were threatened by an individual, would you prefer to be equipped with a pickleball paddle or a golf club? Golf club, 100%. Further reach, heavier, hurts more when you hit somebody with it. You got to get way too close to hit him with a pickleball paddle. Give me my 7-iron. My theory after this this witness, so this dude had a couple drunken slip and fall, eager, crooked cop try to frame who he thinks is guilty, and we get this mess. Would you ever come to Massachusetts asking for BWHRN from Canton, Massachusetts, who would love to meet you? I've been to Boston. Me and my wife went there. We took like a date weekend and went to Boston. It was awesome. Disney Gal, I'm an RN and cracked ribs during CPR. Makes sense. Dr. T, hey, Peter, did you or your audience know, 1, you need to be a member to gift memberships, and 2, it's possible to gift yourself one. Love your coverage. You and me are on the same page like 98% of the time. I don't know if that's good for you, Dr. T. But that's cool. I did not know that. The Mrs. Starr, she said the bruising on his hands were from the IV bruising, but he was already dead. No blood flow. How could that happen? I think he was potentially still alive when they got there. I'm not sure. I'm not a doctor. They would have to explain that to us. All right, last one is 400K by the end of the trial. I don't know about that, but I hope so. Hit that subscribe button, guys. Help us get to 400K. Hit the like button as well. That's all we got. Till next time, I'll see you guys tomorrow, probably afternoon or early evening live. I don't like to do late Friday night, so even if it goes all day, 4:30, 5 o'clock, something like that, you can expect it. But for now, I am out of here. Thanks, Kat, and everybody else who came, commented, asked questions. They saw, they conquered. That's all we got. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.